Hi, everyone. Welcome. Thank you so much for joining us today. So after 28 weeks of COVID webinars, we are very excited to be starting today with our 2020 School Law Conference, with today's session being our first session. I'm Jackie Gadapur-Werns, and I'm excited to welcome you today. For those of you who have been with us for almost the past 30 years, you know that each year we have an annual school law conference for clients and friends, and we're always very excited to get together with all of you, with hundreds of you for sessions on all of the school law topics that are on our minds for the year. And this year with COVID-19, we obviously are not able to all be together, but we are very excited to use this Thursday noon time slot to bring you the sessions we would otherwise have presented at our school law conference. So our conference is going to extend on, it's going to be on Thursdays at noon between today, October 1st, and December 3rd, 2020. We will give you a break for Thanksgiving. Because many of you have become accustomed to spending the noon hours with us on Thursdays for our COVID-19 school law panel, we are starting our school law conference with a familiar topic for the Thursday noon hour, which is the COVID school landscape. I'm excited to welcome the panel that you've come to know and trust. Nikki Baser.
Hi, everyone.
Shelly Anderson.
Hello.
Dana Fattori-Crumley.
Hi, everybody.
And Jennifer Smith.
Hello.
Before we begin, please do make sure to sign up for next week's School Law Conference session on October 8th at 12 p.m. It's called, They Said What? First Amendment Issues in 2020. Presidential election like no other, a global pandemic causing unprecedented economic and emotional toll on our communities, and a remote learning environment where virtual communication reigns means lots of First Amendment issues. So we are, by popular demand, bringing you a session on First Amendment topics covering the rights of employees and students to express their First Amendment speech and also respect the rights of others. So please do check that out on our Frantic Events webpage and sign up for next week's session and for all of our school law sessions. Please submit questions today. You know we love to answer your questions, so use the Q&A function. It should be down in your Zoom toolbar, and we will do our best to answer questions that come to us through that Q&A. And as always, if you have follow-up questions or if you would like more information on any of the topics we're going to be talking about, check out our website at franzic.com or reach out to any one of us or any of your other Franzic attorneys. So with that, let's jump in, ladies. What do we see as the most significant changes in the school law landscape since the inception of COVID? Shelly, what do you think?
Actually, I think I'll just launch it for a second. We'll highlight here for everyone what we see as the biggest topics, the biggest changes in the landscape. We'll go through these briefly right now, and then we'll hit questions on each of them as we go forward. So the first thing, obviously, that comes to mind is the health and safety protocols that we're all following, the IDPH guidance, your local health guidance, how we're incorporating those into reopening plans, how that impacts your liability as a district as we swing into more districts reopening now into hybrid, and how we get boards involved in that work, as well as our administration.
So sorry there, I couldn't get myself off mute for a second. You'd think I'd know how to do this after this many weeks. I think, in terms of what I see is just so many changes as it relates to how we're interacting with employees. And kind of that ranges everything from the accommodation requests that I know you are all being flooded with still and dealing with, whether it's, under the new leave laws or under the ADA, labor relations issues, RIF issues, who do we need now if we're going to continue to be in this remote learning environment? What are the working conditions that are changing? How are we allowing people to work from home or not work from home? So there are a myriad of issues that we're going to touch on through a number of different questions as we go through today that we really have seen kind of transform over these last 7 months.
So yeah, there's the employee issues are horribly significant. The student issues are, of course, are the topic of something in the newspaper on a daily basis. Just the shift to remote learning. We started back in March. We're continuing on now through this academic year, and all the different concerns that come along with that. Confidentiality, student conduct expectations, how we do synchronous, asynchronous, is independent work okay? All of those issues. How do we deal with parents in this environment? And then Jen, there's a whole different set of issues for special ed kids.
Absolutely. So I think just access to education, there's a new question. Do you have a right to in-person instruction if remote is not working? I don't think we have really an answer on that. We have arguments about that right now, but we don't really know the answer of how that's going to sort out. A whole new category really of accommodations as far as the mask requirement, what that means. You're finding, getting information about students with disabilities who never had a reason to come forward before. What does that look like, or how does that interact with pre-existing 504 or IEPs? So those are, I say in a nutshell, what we're mostly dealing with, although obviously there's so much.
Plus a whole new host of issues that's going to come up as we have more districts switching to our hybrid model, both in the student and the employee realm. So we're going to try to touch on all of those, and I'll give it back over to Jackie to lead us along.
Sure. Okay. So let's start out, dig in a little bit more on some of these topics, and let's talk about health and safety. So Nikki, can you talk about reopening a little?
Sure, and I think we're really back to where we were, at the start of, August, where folks were trying to put together reopening plans with the expectation that they were going to at least do hybrid. Then we saw, most of our districts did go fully remote, and now we're really transitioning again, where we're seeing a lot of districts working towards in-person learning. And so again, it's just really reviewing those reopening plans that you created. Obviously, as everybody knows, there has been, and as we've noted on this, this webinar, numerous times there's been updates from IDPH and from your local health officials. And so making sure that those pieces are incorporated. Again, we still stress the idea that boards are involved in those reopening plans through the resolution, so that you have that protection, those liability protections that we've discussed extensively. So if you are looking to revisit your reopening plan, if your board has previously passed a resolution, getting them to approve those updates. If you haven't and want to talk with us about it, we're happy to do so. But again, making sure that your plans are consistent with current guidance, the flexibilities they offer, and also the new mandates that they contain.
Great. So let's talk about employees working from home and how to handle the transition back to the classroom as districts are moving to hybrid or to full in-person learning. Shelley, can you talk about the different categories of employees and how to handle?
Yeah, so I think the way we've been looking at it is, and as Nikki mentioned, certainly districts are taking a turn now as they are looking toward, many of them, going back to some sort of hybrid model, as to teachers who were being permitted to work from home and now being expected to come back to school. For those districts, they're suddenly seeing the influx of requests to work from home and to telework in some fashion. So I think most HR directors are looking at it kind of in three different groups of people. You have obviously the people who are requesting the leave under FFCRA because they have a childcare issue related to COVID. So that's one group of employees who you really don't have the right to say no to. They can either work from home or you have to permit them to take the leave. So districts kind of struggling with what's best for under that scenario. And the second group obviously being are those with health conditions that qualify for an accommodation under the ADA, and whether or not the district can accommodate them by allowing them to work from home, or if there's some other form of accommodation that would allow the employee to be able to return to work. And I really stress this, that just because one district can accommodate an employee and allow a teacher to work from home does not mean that the neighboring district can. It is all about staffing, and it's all about how the district has determined they're going to run their hybrid program. So just by way of quick example, if a district has a group of remote students and they're matching up a certain number of remote teachers for those remote students, but not otherwise allowing any other teachers to go to teach remotely, obviously there's a finite number there. So, working with your union to make sure that you determine best who should get those positions. And then the third category that we are seeing a lot of are people requesting to work from home because they have a family member at home who has a condition that makes them more susceptible to getting very ill if they contract COVID. So working with those three groups and determining how you can best staff your school depending upon the model that you're working with. And that is going to continue to change. So also being sure that if you say to someone, we can accommodate your request, being clear that it's not for an indefinite period of time, but as this whole period changes, there will be a time, hopefully this school year, that teachers and students will all be back in buildings together, and we'll see this kind of remote environment as a thing of the past. So being sure that you're clear on timing there.
Yeah, and I think, we saw this when districts originally planned to go back, and now we're sort of seeing an uptick again. And I think the last category you talked about, Shelley, is in some ways the most challenging, right? Because obviously a lot of districts offered flexibility, telework for those folks out of compassion for their concerns about family members, even though we know under the ADA and state law, you don't have to provide an accommodation because of an employee's family member, child, parent, whomever they're caring for. Now, we're going to be in those tough situations again, where if you, attempt to accommodate an employee, but through, different accommodations in the school building and they still refuse to come back, then you're talking about, are they eligible for leave? Is this something where they are eligible for something like FMLA leave? Or are we looking at unpaid leave or possibly even an exit from the district? And those are really tough conversations because obviously we want our teaching staff to remain intact. But at some point, as you mentioned, depending on the needs, if you have students in a classroom, you are going to need, teachers in the classrooms too. And I know, Shelley, you've been looking at this issue of using parapros, which has come up quite a bit with ISB, and I wondered if you had an update on that.
Yeah, so one thing that did come up a lot, we had a lot of questions from clients about was, if we do allow a teacher to teach remotely from home, but we have the kids in school, how do we handle the supervision of that classroom? And what we determined is that when you look at the school code and the regulations, the paraprofessional who's licensed certainly has the ability to be in that classroom and supervise students, provided they're not providing the instruction. They're just there for supervision. Perhaps they're turning on the monitor, things like that, making sure the kids stay 6 feet apart and keep their masks on. The issue really came down, ISB put out guidance indicating that there had to be someone within a license of some sort to carry out those duties, which doesn't necessarily, at least from our perspective, is in accord with kind of what the law says, that we can have someone supervise without a license. So we did reach out to ISB, we did work with them, and it's our understanding that there will soon be published clarification that indicates that under the circumstances of COVID right now, with a few caveats that we'll hopefully see shortly, that you will be permitted to have non-licensed staff fulfill those roles, which I think will help greatly with some of these staffing issues that a lot of districts are having. Is to, we want our amazing calculus teacher to be able to teach our kids calculus, but how do we do that if he cannot come to school and we don't have another person to sit in that classroom, or we don't pay for a sub to do that? So hopefully that'll help, and hopefully we'll see that yet this week.
That's great. So Jen, we've talked about getting the employees back in the classroom. Let's talk about getting the students back in the classroom and into the building. So what are the legal considerations that people need to keep in mind when they are transitioning back to the building? Are there concerns about providing only remote instruction to special education, for instance?
Sure. So I think there's a couple things, and actually to start with what Shelley described, I mean, that might be a good place to start. If we're bringing students back into the building, but they're still remote learning, for example, that's going to have kind of one set of concerns. For example, if their accommodations still need to be implemented. So even if they're remote learning, now they're in a different environment. What does that mean as far as the implementation of their accommodations? Does the whoever the supervisor is there anything they need to be aware of in order to accommodate? It also as painful as it might be, if you did remote learning plans, but now you're moving to something that you didn't envision when you first did those remote learning plans, it would be time to dust those off, because the gap between what the IEP says, whether it's in the actual IEP or an amendment to the IEP that included the remote learning plan, we need somewhere to say, accurately mirror what you're going to be providing. So if you're going to blended and your remote learning plan didn't take into account that, we might need to update the remote learning plan, or maybe call it a blended learning plan, so that there's clarity in communication and agreement. There's a meeting of the minds between the parent and the school team on what services are going to be provided, what goals are going to be worked on, what accommodations are going to be implemented. So any gap between what the documents say and what you're doing presents a legal risk that should be addressed. The other thing, just as we're coming up on first quarter for many districts, that means progress reviews, and we should be getting data on how students are doing progress-wise. If students are not making expected progress, that's another presents a risk where, hey, we need to look at that. Why aren't they making the expected progress? What can we change? With special ed law, it's often a trial and error process. So we can't just, if you don't have in-person available, or if you have a limited in-person available, we can't just throw it out and say, well, remote learning doesn't work. We have to think of something else we can try, whether it be remotely, or if now we're moving to blended, we have something else we could tweak. We need to constantly be kind of evolving to address any concerns that we're seeing with the data and the lack of progress.
All right, now what about other special populations? So individuals with, you just mentioned IEPs, those with 504s, English language learner students, other high-risk students. Dana, can you talk us through accommodating these special populations?
So I know different districts have done things differently, and I think that's okay, because I think the guidance is very general. So if you go back to the beginning, when ISB issued its guidance about how kids should be returning to the building, there was that initial recommendation that we should prioritize special education students. We should prioritize English language learners. I think some districts have also identified groups of kids that don't have good internet access and can't learn effectively in a remote setting. Maybe they're, districts that have high incidences of low-income students, where even if they have internet access, they might be trying to learn in a 2-bedroom apartment with, 10, 12 people living in the same space, and that's not conducive to instruction. So I think districts have looked at that different ways, and there has been flexibility to do that. As far as bringing those kids back, then you have to start dealing with the accommodations. Just as we bring teachers back, there's accommodation requests. As we bring students back, there's accommodation requests. I know there's districts that they've brought back some kids, and then they're going to have requests from other special education parents that their kid may not be in that initial group. Why can't my kid come back? They're going to have people coming back who they want to come back, but they can't wear masks. And I know that we've been looking for, in special education, especially some overarching guidance from the U.S. Department of Education, or for some place that can simplify these things. But unfortunately, as Jennifer knows, we have none. Everything has to revert through the IEP process. So how you're serving special ed kids as you're getting requests from parents, whether it be for an accommodation, or whether it be for in-person versus remote, or whether it be for some additional service in remote, you really have to treat that as a request for a meeting and run it as a meeting and problem solve it that way. So I know that's difficult for us, but it's just one of the many challenges, and we're seeing people work through them. Sometimes it's, when you actually start, it's daunting, but as you get into it, you have systems, and what you've always done starts to work again. So we're hopeful that that will be the case for most of you.
So let's talk about quarantine and exclusion. I know that we've all been watching as there have been situations across the state where, someone gets sick, someone is expected or suspected of being sick. So let's talk about, Shelley, what can districts do as far as quarantine and exclusion policies? Can they have more restrictive policies, then those are mandated by IDPH or local health officials. What do you think?
Yeah, so I mean, I think that there we go. I think as many people know, that they are constantly changing in terms of what the exclusion guidance is, and kind of trying to keep up with that and make sure that we are kind of following it both from IDPH as well as the local health departments and what exclusion guidance they are putting out there. But in terms of whether or not you can be more restrictive, certainly my position is that you can be. You know, you are all working so hard to get kids back to school, many of you. And the idea being that to do whatever you can do to keep the kids who are there safe and to keep the exposure as low as it can be, that if you need to, for instance, you know, there's, you know, Cook County and Chicago has specific quarantine if you travel to a specific state or specific group of states. That does not necessarily mean, you know, that if you're outside of Cook County that you have to do that. But certainly if a district wanted to say, if you travel to one of these states, we need you to stay home for 14 days and be a remote learner during those 14 days. Certainly I do not think there's going to be any legitimate challenge to that. Perhaps the parents don't like it, but that's just one example, kind of a travel exclusion that I think a district could safely implement, with the focus being on, we want to keep this moving in the right direction with kids and teachers in school. In order to do that, we have to rely on our families to cooperate. And part of that might mean if you make a decision to go here or there or do this thing or that thing, that you are then accepting that you will have to be out for at least that 14-day period to make sure you don't potentially get anyone else sick in the school building.
All right, so let's say that we do have someone who is sick or suspected to be sick in the school building. Nikki, are districts allowed to disclose information on cases of COVID? Specifically, can they share things like student names with the community?
Sure. So, you know, we actually just got updated or resent guidance from the U.S. Department of Education on this question, which is really helpful. You know, absolutely, you should and can notify the community if you have a positive case of COVID. As we actually talked about last week on the webinar, the individual student's name should not be identified in that communication. I know districts are taking different positions on whether they just send out a generic, there is a student in the school community. Some districts are drilling down to the school building, even to the grade level. I think the one caveat you just have to keep in mind is that you do need to keep the student's name or identity confidential. And so if you are putting out information, you have to decide whether, in combination with other information that may be out there, whether what you're putting out will reveal the identity of the student. So if you have one second grade classroom and there's 10 students and one student is absent, and you put out information that names the school and the grade level, that may reveal the student's identity. So you just have to think through that process. Interestingly, the Department of Ed has also said that there are some circumstances where, under the health and safety exception to FERPA, you could potentially release the student name. The example they gave, I thought, was kind of fascinating. The example was that if a student athlete tests positive for COVID and has been in close contact with other students on a sports team, or the students who have higher health risks, then the school officials may determine that the other students or their parents need to know the identity of the infected student in order to take protective measures. I would be very cautious about doing this and really talk to counsel before you do. I'm not certain why you would need to notify an entire sports team as to the identity of the individual student. Potentially, I suppose, if there are students with a higher health risk, that may be important. Although, again, the name seems potentially unnecessary as long as they know that they've been in close contact with someone who has COVID. So again, rule of thumb, don't release a student name. Try not to give out information that would reveal that identity. If you feel like you need to, touch base with counsel and we can walk you through it.
Yeah, maybe something to add is under state law, and I think this is why you're saying reach out, there are documentation requirements. So if you're going to make that health and safety determination and release, you need to have your paperwork in line. So yeah, if you don't already know what it is or have your forms, just do reach out and make sure, because it's not something you can just decide and do without jumping through some hoops.
Yeah, and obviously work with the family, because there may be some instances, like on a sports team, where the family is not concerned about having the student name released, and if they consent. The same with, employees. You should not be releasing employee names. Obviously, FERPA is not implicated, but there may be some circumstances where the employee is fine with it being released. They think it would be helpful for contact tracing, so go ahead and get that consent from the employee, and then you can release. Again, we're trying to keep people safe, and I think a lot of people realize that, so they may consent to the release for that purpose as well.
All right, we did actually.
Yeah, I was just going to address it. We have an inquiry here that I am positive that I have answered already from you, but I think he's maybe looking for a different answer. I think Tom might be lawyer shopping. So the question relates to whether or not we should combine staff and student names on the dashboard. For those of you who have dashboards, and I highly recommend that you have dashboards to be transparent with your communities about the positivity rates or cases that you have in your community. It's different district by district. I definitely don't think there's any problem with separating students and staff in terms of letting the community know who might be positive and who might be quarantining. The thing that I think with respect to dashboards generally that I'll say is you just want to make it clear that when you're indicating that people are quarantining or that you're indicating someone's positive, that does not necessarily mean that there has been exposure in the school. There's lots of reasons people have to quarantine. And I think that districts who aren't being clear somewhere on the website might be sending the wrong message to the community about how widespread the problem is now that we're back in school. And, in some cases that might be an issue that you're dealing with, but if you're not, it's really just because there is something going on in the community outside of school that's causing people to have to quarantine, or staff members who are engaging in behavior that causes them to get COVID, having nothing to do with school. Making sure that you're clear that this is not necessarily kind of school-based cases in your dashboard reporting.
And just to be clear, Shelley, because you mentioned names, I think the question was about numbers. So obviously we're posting numbers on the dashboard, right? Not individual names, and separating students and staff may make some sense there. And I know that Tom loves you and is not lawyer shopping, so.
Well, and this absolutely would not apply to Tom considering the size of his district, but the only situation I can think of, and Nikki, you kind of hinted at this, where the numbers would be so small. So let's say you had a special transition program or something with a small number of students in that building. That's a situation where you might want to consider combining the numbers, just because once you get to pools less than 10, that's when we worry about releasing numbers, as it means you're identifying possibly someone. So definitely will not apply to Tom, but I shouldn't say that. Maybe they have a program or a building that's less than 10, but I kind of doubt it.
Yeah, I just got from a client, from a school client yesterday, a very snotty message from a parent after they had issued a letter about a positive case, about I want the name, birth date, height and weight, hair color of the person that was found to have a positive test. And in this case, it was someone that contracted it outside the school context. So I think, and I think just making sure that the communication is not revealing anything, explaining to people how you're going to do it, being really transparent. The purpose is to keep everybody safe, not to make people feel like scapegoats or pariahs. And, to do that, I think you have to keep everybody together and make them feel that you're being as transparent as you possibly can be. And that's when you set that up, I think you have people willing to work with you as far as the contact tracing and telling different parents, sharing it willingly, sharing things willingly. So sort of setting the tone is so important. And I will say, on the behalf of all of us who all have kids, we will never sign an email to any of our schools ESQ. That's very snotty, necessary.
I just wanted to answer the question in the chat. Someone asked if we were able to review a district's proposed dashboard for any feedback. Absolutely. We're happy to take a look and see if there's any areas of vulnerability in terms of legal issues and also clarity of the message, the points that Shelley touched on. So happy to do that. If you need, you can reach out to any one of us.
All right, so switching gears a little bit, we talked a little bit about special education issues and in-person instruction. Where does the law stand, Jennifer, on whether special education students have a right to in-person instruction?
So very unclear. I do not, I should just say I don't know and move on. But I think we will know at some point, and I am desperately trying to keep all of you from being the individual district that has to find out, because no matter what the answer is, the process is taxing to get an answer to something like that. But what I will say is a number of districts are facing challenges and facing them from a number of different perspectives, whether it's from a special ed faith angle, from a discrimination angle, from a broader, we just have a right to in-person instruction. We're getting those kind of demands totally separate from disability, but just things like the requirement that students opt in or opt out for an entire semester. Will parents saying we have a right to more flexibility, or parameters being put after someone travels to a high-risk state, a family travels, or so we're getting a number of different contexts where this concept of a right to in-person is coming up. There's no, I mean, to me in the law, there's no obvious source of that right, but I can certainly see there's a certain logic to it where you're maybe taking something away from someone because it automatically values in-person higher than remote. And I think that's tricky. I don't think that's necessarily accurate, but I certainly am getting a lot of arguments down that vein, and hopefully to maintain flexibility that you need to provide health and safety, it really can't be that you have an absolute right, that a parent has a right to in-person. That would be highly problematic. So at this point, I'm saying I don't know, not because I think there is one, but because there's so many challenges and I don't know how those are ultimately going to be resolved.
Yeah, I think this sort of dovetails into our next question, which is about this idea of, and Jen, you touched on it, which was a lot of times, a lot of districts, when they requested that parents at the beginning of the year make a decision, even if we go hybrid, say in October or November, what are you going to choose? Are you going to choose now remote, or are you going to choose hybrid? And you won't get to change from remote to hybrid until the semester break, or in some cases the end of the year, sometimes the quarter. And we now have parents who are sort of seeing that districts are opening safely and they want to switch that. And I agree with you. I don't know that there's clarity. I think at this point we are counseling that for general education students at least, you know, requiring parents to sort of stick to the decision that they've made is lawful. You know, we haven't seen that challenge yet in court, as you suggest, Jen, so we can't definitively say yes or no, but I think we have a strong position that, yes, you can say, look, you made the selection, we've planned our health and safety, and in our capacity as a district to maintain health and safety, we are going to keep you to your choice so that as we transition, we're able to do so. I think, as you say, for students who are receiving special education services, I think the calculation is a little bit different. Dana, I know you and I had talked ahead of time about needing to potentially reconvene that IEP team and talking through if a parent is requesting to move from remote to in-person, not at that semester break, sort of midstream.
Yeah, I mean, I think that's the strongest argument. I think that when I look at these cases, I think that trying to make an argument that everyone has a right to in-person is probably not a valid argument. However, I do think that districts need to be aware that I think the greatest risk of somebody prevailing in this area is if you have a special ed student that has, you know, started on remote, maybe chosen remote, or maybe you didn't have, all your offering is remote. If they're really making no progress, and we're in a situation now where private providers are open, you can go to the doctor, you can go to the dentist, we're going to have an issue. We're going to have to work with that individual student through the IEP process to make sure that we're addressing that needs and we're changing things up to try to get some growth and some gains back. And if you just do nothing and say, oh, health and safety prohibits us with all these other things going around you, especially when you might have a district in a totally different situation, right next door, open. You've got to be mindful of that. And there's different ways to settle things. You don't have to, that doesn't mean you have to open up. You don't have to bring them back necessarily full time. There's, you know, a million different resolutions in between there. You just have to be a good brainstormer and think of them. And you know, work with all the tools that you have, and maybe that's some outside providers, some outside services. But it's definitely a hard issue, and it's going to remain hard as we go in and out. And just the impact on special ed students and on younger students is just greater, and we can't, you know, deny that or try to bury it. It just is, not to use that horrible phrase, it is what it is, but it is harder on them. Yeah.
Well, speaking of things that are harder on younger students, as I have my little ones in the other room glued to their screens, we are all glued to our screens these days, it seems. We are all always on Zoom and on other video conferencing and other platforms. So Dana, let's talk about that for a minute. What are the issues that are related to providing services, so particularly one-to-one services for students over Zoom, and what should we be thinking about in relation to confidentiality?
So Zoom makes confidentiality difficult. I think we have to start though, I think it's also difficult to talk about this with teachers, because teachers are very concerned about other people seeing them teach. And I think you have to start from the premise of, like, instruction is a public act. It's a public school. People are paying, everybody's paying into it. They get to see what biology textbook is. They get to see what biology instruction is. None of that is confidential. We can't claim confidentiality on that. But, you know, teachers are worried about other people coming into the screen, hearing things. You know, I don't think that's really in practice been as big of a problem as we thought it would be. But that being said, I think you do need protocols for observation. You should set up parameters for parents about what's accepted conduct. You don't want someone else, like, looking at the class. A kid could be having an issue, could be asking a question. It can really stymie the kind of climate that you want to have, even in the virtual setting. You know, I think people are worried about doing related services. The other kids are going to hear, the other parents are going to hear. That is another concern. I don't think that it's a huge legal concern. We haven't seen huge challenges. What has anyone else heard about that? Jen, what do you think?
Yeah, you know, actually, I haven't had so much about confidentiality from a observer perspective, but I have gotten a lot of concern about the question of, can we require students to have their screens on so we even can see who's there and see that they're engaged, and coming at that from both sides as far as an equity perspective of, what if a student is in a not ideal situation that they don't want to reveal, that it's embarrassing or socially, emotionally difficult to reveal to their classmates. You know, how are we handling that concern versus, I think what the feedback at this point is that when students don't have their screens on, we're just very suspect that they're not engaged. And it's very hard for the teacher to actually teach when they can't get any confirmation that the student's engaged. So we don't have super great answers on that, although I think you can set an expectation to have the screen on. I think that's a reasonable class learning behavior, that just like in class when you have expectations. Now, whether you should, just because you legally can, whether you should, and for certain, you know, like I mentioned, there's certain circumstances where that might be a barrier to instruction for students. So just like anything, that needs to be problem solved, but I don't think there's one answer that's always going to be the right answer. But those are the concerns that I'm hearing about Zoom still at this point.
I have to say that I have this argument with my 12-year-old who is a 7th grader every single day. And it's not that he's, you know, upset about his background or anything like that. It's like he's 12 and he's embarrassed about everything in life. And so therefore being on the screen is just like overwhelming for him. And I look at his classmates and they're all off of, none of them have their screens on. And I feel terrible for these 7th grade teachers who haven't met any of these students in person, but I know it's a constant struggle. The only thing I wanted to add to what both Jen and Dana were talking about is just from a legal perspective. You know, we've had a lot of questions about whether you need consents for particularly one-to-one. We've talked about this quite a bit in other webinars. I don't think consent is required. I do think notice is a very good idea. You know, in terms of advising parents whose students are getting one-to-one service, all about the things that we've talked about here. Look, it's not 100%. We can't guarantee 100% confidentiality. You shouldn't be recording it. You shouldn't be taking photos of the sessions to the extent that students can be a quiet area. All of those things should be in the notice. For some districts, consent works. In others, it just is hard to get parents to send those forms back. And I think notice works really well. So there's a ton of issues there. We're happy to work through those if you have any specific issues, as a lot of folks have been doing remote now and are pretty adept at it. But I think
I also don't like to get consent for things that you don't need consent for. It makes me nervous. And let's just add to this whole conversation that HIPAA does not apply. It's our button for the season. There's no concerns with providing service over Zoom. Does not apply.
Nikki, we did get a question in the chat that definitely caught my eyes. I'm sure you have some thoughts on it. But so the question is, what issues have we heard about software or apps that would allow a teacher to, I guess, check in on a student when they are even, when they're not in class? So for example, they can close tabs and see what's going on the screen of what a student has at home, and they can do that during the workday, but they also, I guess, presumably would be able to do it at 10 o'clock at night to see what a child is doing. And I know that definitely raises some flags for me, but Nikki, you want to answer that one?
Yeah, wow. I would love to hear what you have to say, Jackie. I actually have not heard about this, which is unusual since you and I are the tech folks. I have lots of concerns about this. And in terms of the sort of invasion of student privacy, what teachers are viewing, what they're doing with that information, I would, counsel a district against using such a program unless we really delved into the purposes of it, how it was going to be used, the controls. And then certainly I'd like to understand in terms of GoGuardian, that was the one named, or other such, we would have to look very closely at their privacy policies, because the kind of access that the app or the software program itself, what are they pulling from these students and what are they maintaining? I mean, as everybody knows, we've talked about sort of every chance we get, there's new amendments of SOPA. We have to look very closely at any kind of software where student information is being, obtained by the companies.
Right. And I think your response to your teachers sounds very good, which is that, we definitely don't want them checking out what's going on outside of when they're working with them. Sorry, Jennifer, what's up?
No, I was just going to say, I've heard simpler solutions to concerns about students on tabs they shouldn't be on during class. So apparently, well, at least I know a district or two that you can put parameters, like not allow students to open additional tabs. And I've seen that as an accommodation for students who are rather distractible, and be implemented with some success. So I think there are simpler solutions that maybe don't raise the same privacy concerns that I would go to as a first step.
Yeah, but definitely let us take a look at, if you're wanting to work with a program like that, as Nikki said, it's a very important to make sure to understand what the parameters of the use by that company might be. So definitely a great question and very interesting to hear about. All right, Shelley, so switching gears again, let's talk about labor relations, which I know there's a lot to talk about. So what have you seen? Give us a general sense of the impact of COVID on labor relations.
Well, I would say that there are exceptions to this, but overall, I don't think it's been great. I think that this has caused a lot of friction in even some of the districts that I know and work with that have had historically great working relationships. I think that the lack of clear guidance from the state, and as much as local control is so coveted and is so important in many respects, in this respect, I think that that is what is leading to a lot of frustration between union leadership and administration as to how to best move forward, because it is all left independently. And so your neighboring district is doing it one way and you're doing it another, and there's not a whole lot of explanation as to why, nor should there be necessarily, but without that kind of clear guidance from the state. And even when we're getting guidance, sometimes it's not timely. So, we appreciate so much everything IVPH and ISB is putting out. The unfortunate thing is, because this is all moving so fast, no blame on anyone, but sometimes we're getting guidance out after decisions have already been made, after decisions have already been negotiated with unions, and then we're having to backtrack and decide how that impacts it. So I'm hopeful that, things will start to move in the right direction now, that some of the hardest is over, but I say that with the reality of that, the hardest is probably still yet to come as we kind of see how long this whole process is going to be and the different nuances that it's going to raise between employers and unions. So I think it's not been great, Jackie. It's certainly been my experience.
Do you have any thoughts on how to rebuild the relationships moving forward?
Well, I mean, no different than I have said in the past, to many people who are probably listening, in the seminars we've given on kind of how to rebuild relationships, but, really making sure that you're identifying the issue early on with respect to, what is it that's causing the conflict between the two sides. And in this instance, it's, likely people are afraid, and they're afraid for their health, they're afraid for their family's health, and really kind of talking through that and honoring it and kind of talking specifically as to why, for instance, you can keep people safe. I think if there's someone divisive on the bargaining team, you have no control over the union's team, but certainly on the administration side, if it's someone who's been kind of the source of problems, looking to remove them. I usually say, sit down and eat with people and chit chat about your families. I know you can't do that now. So I think that's also been hard, is that we're all trying to bargain in this format, which is, taking a lot to get used to. But the last thing I'll say in terms of making sure that you're kind of building trust and getting back there is, being really mindful that you're saying what you mean and being transparent about it when you're talking about situations, and that you're watching your body language and everything else. And I will tell you that this has been the biggest lesson I've learned through Zoom, is that when someone says something, I have a very specific facial reaction when I don't agree with them that I would have never known had not for COVID and having to see myself during bargaining sessions. So I will warn everyone about that, just being mindful of how you are, responding to people with your facial expressions, because obviously now it's on display for all 12 people who are looking at you. So, but I'm confident. I'm confident things will get back to a better space eventually.
I have really noticed that myself, Shelley. So it's a very interesting phenomenon when you can actually see yourself, and can be helpful in some ways. So let's talk about, Dana, student discipline in a remote setting. How do we think about that?
Yeah, I think it's the same thing as what Shelley said. I think that if you don't want to have discipline problems, you have to start off with relationships, right? Like that, just as the leadership of the school is working with the teachers union, so the teachers have to work with the individual students. And I don't think you can impress that upon them enough. So whatever tools you can give your teachers to making connections with students, we're talking about students not having their camera on. I do think every teacher has to just be transparent, address the elephant in the room. This is going to be different. This is how I think we should run this. Give me your feedback. I've seen districts have, in elementary classes and in high school classes, a little one period where maybe the teacher checks in for 5 minutes individually with each kid on Zoom and says, what do you think about it? And then they don't have to talk about it in front of the other kids. So I think setting things up like that can prevent problems from coming later. I do think that you need to have some standards though. I know that there's equity issues about, showing your screen, but like Zoom we have technology, and I would really consult with your AT people. Like, how can kids set the background they want? Does somebody want, like for littler kids, do they want a rainbow? Do they want a pony? Do they want Spider-Man? Do they want, I think we can make positives out of these things, and you have to look for those things where you can find them. But I do think that when you do set rules, and I think some of the basics ones are like no doing your Zoom in bed, no vaping on camera, no, I can imagine some of the little smart alecks that we have that just like to get those middle-aged women teachers that are in my group just all crazy. Because I have a teenage boy, and sometimes he does it just to, I'm bored, let's get a rise. Then you can discipline them. We can exclude them. All of the same things apply. We haven't had any changes in student discipline, but I think you got to be mindful of how that's going to impact kids and be flexible there too, because we're in a time like no other. And really, if the teacher can mute people, gosh, if I could have muted people live, I'd still be teaching 8th grade right now.
All right, Shelley, what about staff discipline? What's happening there? What should we be thinking about?
I think it's the same as what Dana just said in terms of, obviously it all still exists there in terms of the district's right to discipline staff, whether it's you're in a remote setting or an in-person setting, and just being mindful. I've heard a lot of, teachers concerned about this idea of, well, if someone's able to record me and then they put that recording out there, could I then be disciplined for something I've done with respect to the classroom? And my answer to that is yes, because you shouldn't, if you're just because it's being recorded doesn't change the nature of what you've done. And you have to really look at that and think that, we expect our teachers to be professional. I trust that they are being professional. For those who are not, the same way they would perhaps not be in an in-person environment, they can still be disciplined the same way that they could otherwise be. We just might be learning about it in a little bit of a different way than we otherwise would if it was having to wait for the principal to walk by and pop in your classroom.
So Nikki, thinking about staff conduct and performance, what are we doing about evaluations this year?
Happy to answer that. I'm still stuck on wanting a pony background. So Dana, just let me know when you figure that one out. So evaluations have caused a lot of conversations, I know, amongst all of you. One thing I just wanted to make clear is, as Shelley talked about, you can continue to do observations of your teachers. You can continue to look at performance issues. In terms of evaluations, there's been no statutory removal of the obligation to evaluate. But as everybody knows, there has been some amendments and some joint statements put out that indicates sort of the desire for some flexibility here. I know a lot of districts are entering into MOUs, MOAs with their unions about, what happens if folks don't get evaluated, the potential for not evaluating at least the tenured teachers this year. We have some draft MOUs that we're happy to help you work through if that's still an issue. One thing to think about when you're writing your MOUs is the different categories of teachers. So if you're fine with not evaluating the tenured teachers who are proficient or excellent, who are going to default to proficient or excellent, but thinking about whether you want to continue, for those needs improvement teachers, are you going to be evaluating the teachers that are struggling or that that you are consistently concerned about? How are you going to handle your probationary teachers? So all of those issues can be worked through. It's something that you're going to have to sit down and talk about with your union. But, I think a lot of people are looking for flexibility here, understanding, the dynamics of trying to evaluate in a remote setting.
So Dana, we have been seeing a lot of people relocating because of COVID. So can schools allow students to attend remotely when they've moved in with grandma in a different state?
You think I'd get better at this by now. So I think the whole issue is, are they still a resident of the district? If you're moving in with grandma temporarily and your intent is to return, maybe you're moving in for a few weeks because your parents need help, managing and caring for the rest of the family for a while, then you're still a resident. If you're moving permanently, that's a different situation, although kids can finish the year. But I mean, Jennifer had a crazy situation about somebody moving across the world. And I know that with the college kids, they've also had situations where people are moving to Asia. And I mean, frankly, if, reading is at 10:10, I don't know what time that would be if they moved to, Seoul. It might be at a very inconvenient time for people to get out of bed and take reading. So you have to consider those practical issues as well. But I think you have to really work through on a case-to-case basis. What is the reason people are leaving? Are they coming back? All of that.
Yeah, another practical question or consideration, Jen, is what about providing related services over state lines? What do you think about that?
So you can. We know from the orders that have been out during this time that there's not a licensure problem. So, or it's not going to, we always hear it's going to hurt my license if I'm out of state. But at least as long as if they're for Illinois students, and remember these are related services, they're not So their school social work services. So it all goes through that lens. We have had broader concerns about whether it supports the school community, the manner in which it's done quite distantly. So I'm not going to say, so it's not illegal. Is it a good idea? And especially as you're planning for districts who are always trying to move towards an in-person model, it demonstrates a significant barrier that gets parents' cackles up. You know, they're like, well, obviously you're not reopening. I can see the teachers, you know, in the Bahamas or whatever. So it raises issues, but it's not I don't think you can't because of the certification or licensure.
So before we go, we have a bunch of really good questions in our chat, but before we go there, Shelley, I want to ask you if these considerations are the same if a staff person moves to another state.
Yeah, this has certainly come up in a few different places, this idea of if we are remote learning, can the staff member do it from somewhere warmer, for instance, you know, as it's certainly about to get cold here. And I think that really depends on the district and the situation. So I think that, you know, in one particular circumstance, I'm thinking of the idea being that and this all comes down to kind of what you put on Facebook. I feel like every time we talk in one of these, it comes down to someone posting something on Facebook that gets them back in trouble. But I think that with a particular circumstance I'm thinking of is a teacher who had traveled someplace warmer and had posted on Facebook all the fun things they were doing there, leaving the sense in the community that the teacher was out on vacation, leaving a sense with her colleagues that she wasn't doing the work that she was supposed to be doing, which could then also cause all sorts of morale problems and issues with internally. So I think that unless you have a policy against it, you might not be able to prohibit teachers from teaching somewhere else, provided they're doing their job and doing it, you know, correctly and at the times they need to. But certainly I think it's worth a conversation as to whether that's the best idea for a staff member to be doing that.
Well, I did it too. 3 of us in one session. So we'll figure out the mute maybe in, you know, 2021. So we do have some really good comments and questions, which I'll just go through very, very quickly. One of the questions was if a student's parents have not provided required health records by the Illinois deadline of October 15th. What do we think about that?
So this is an assuming that you're still remote learning and no one's in person and the student is not participating in any extracurriculars. So I'm not sure I would feel comfortable excluding the student if in a completely remote setting just because they don't have their required physical in. I think I would be working with the student, connecting them to the public health agencies, different resources that we have in Illinois where they can get that physical taken care of. We know those are up and running. I would not exclude. I would, however, if the student wanted to participate in athletics or do anything that was active or do anything that was putting them in contact with other people, I do think that can be, just as you would enforce it at any other time, then you're going to enforce it. But to enforce it when you're purely remote and remove the student from the Zoom because he didn't go get his, you know, booster shot is not probably appropriate.
We had a really good comment about just keeping in mind the diversity, equity, and inclusion issues that may come up with disciplining students. And yeah, we too have seen articles discussing how, just like in discipline in the building, discipline in remote learning can sometimes be applied in ways that is not taking into consideration civil rights responsibilities. So definitely make sure that you are doing that. And we did have a comment that very timely question on the students moving because they have a family moving to Texas and wants to stay with their district. So it is 1 o'clock. We want to be cognizant of your time, so we will let you all go now with the hopes to see you again next week for our session on First Amendment. And in the meantime, if you had any questions about what we covered today that we didn't get to, please don't hesitate to reach out to us. You can reach out to us individually, or you can always find us at covid@fransic.com. And until next time, please take care. Thank you for joining. Bye, everyone.